Welcome, this is Anand Gupta. Today we will try to understand Article 14, a promise and commitment to justice. And if you're preparing for civil services, you already know that understanding this is extremely crucial to solve both prelims and mains questions, which are nowadays becoming more and more applied. You have seen last year in UPSC paper 2. So let's declutter this article together. But first, let me ask you one very simple question. Do you treat every single person you interact equally? Can you treat your father and friend equally? Is it not now very difficult to answer, right? You simply can't. Father is father after all. Papa papa hai, dost hai. But even though you would treat them differently, still your friend would expect that you do not abuse him, if not respect him. Meaning he would expect that you treat him with dignity. To strike that golden balance, our founding fathers really thought through. Because they knew the road to achieve justice, which is the aim of our constitution, is a bit more complicated than just having one rule for everyone. And this puzzle of balance was solved in formulating Article 14. It says, state can't deny any person two things. First, equality before law, and equal protection of law. The second thing is just two short phrases in one article. In Hindi हम कहते हैं गागर में सागर भर देना. Now you might read and think, okay, this seems very straightforward, but trust me, these two phrases make up one of the most dynamic and debated phrases, both in courts and outside. You will frequently find mention of Article 14 in newspapers, in Hindu and Express, or whichever article do you read, newspaper you read. So let's unpack it and see what really makes it a powerhouse of all of our rights. Here is how we will go. We will start with key phrases themselves, and then we will unpack two different sides of equality that it guarantees. We will dig into its foundation, the rule of law, before we get into its application part, like how and when the law is actually allowed to treat people differently. And then we will wrap up by looking at some necessary exceptions and a few landmark cases that show this article is applied in our life. Alright, let's get started. First up, the two-line powerhouse. You see, the real power of Article 14 begins with the very first word in text itself. The article says any person, any person. And that phrase, think about it, those two words are very important. Is this protection available only to citizens of India? No, no. It extends to everyone within the territory of India, citizens or foreigner or even what we call legal person like trust companies. It is a kind of universal guarantee that our constitution promises. We must also admit that this is what makes India democracy in a very substantive manner. Remember Ajmal Kasab? He was given right to defend himself in court. Imagine, would this be possible in China, North Korea, Iran? No. Plain answer is no. Okay. Okay, now let's get into the real heart of Article 14. You will notice it doesn't just say equality once, it gives us two distinct concepts. First, equality before law, then equal protection of law. And that's not just a repetition of equality, it's actually a brilliant piece of constitutional design. So let's put these two ideas side by side. Equality before law. It comes from British common law. Think of this as a negative concept. It tells the state what it can't do, limits the power of a state, making sure that nobody is above the law. This is what in Bollywood movies you would have seen. कानून अंधा होता है और सब लोग, from you and I to Prime Minister of this country to President, all are under the same laws of the land. If that's the case, why PM travels with so many NSG commandos and we do not even have a constable with us? Think about it. Let's come to the second part of the article. Equal protection of laws. an article that we have borrowed from American Constitution. This one is a positive protection. It actually requires a state to do something, to act, to make sure people in similar situation get treated similarly. To make things more cohesive for you, let's take another scenario. A judge makes two people sign the exact same amount, 1 lakh rupees bond for granting bail. Okay. On the surface, that satisfies equality before law. But what if one person earns 4 lakh a month, like a CEO of an MNC? For him, it's just peanuts, barely a penalty. For the other person, he only earns 4,000 a month. For him, the same bail bond is another punishment. You see, the treatment was equal, but the outcome was deeply and profoundly unjust. And that is why we need equal protection of laws, which gives the laws the flexibility to treat unequals unequally. So let's understand its theoretical underpinnings. Where did this big idea of equality before law even come from? Well, it is a direct expression of much older, really foundational principle of rule of law. The concept of rule of law, which was famously explained by British jurist A.V. Dicey, is actually very simple but very revolutionary. It says that the king is not the law, but the law is the new king. Here, law is supreme, not the government, not the prime minister, king, queen, president, be that may. Every single person is subject to ordinary law of the land. Now, the Indian system fully embraces Dicey's first two principles: supremacy of law, equality before law. Yep, they are bedrock of our democracy, we know it, and we differ on the third one, predominance of legal spirit part, that suggests right arises from judicial decision judgments, writs, not codified laws. But in India, it's other way around. Our fundamental rights flow directly from the constitution itself. So let's come again to the second part of Article 14. If law has to treat likes alike, it logically follows that it can treat unlikes differently. Language is a bit complex, but you will understand. But how does the state decide who is unlike without just being random or unfair? This brings us to concept that is absolutely crucial to understand, the test of classification. Can government make a law and gives only one tribe in Arunachal Pradesh reservation in civil services? Your right answer is no. Article 14 allows something called reasonable classification. Any classification must be reasonable to achieve justice. Justice, which is the aim of our constitution. Therefore, it forbids class legislation as it promotes injustice. Now you link preamble to here, right? So let's understand the difference a little more. Well, reasonable classification is based on a real logical substantial difference between groups, and it is done to achieve a legitimate democratic goal, namely to promote justice. Class legislation, on the other hand, are just arbitrary. It's like picking a group and giving them a special treatment for no good reason. One is a tool for justice, other is a recipe for discrimination. So who would determine that reasonableness? Of course, courts, High Court and Supreme Court. Well, Supreme Court developed this incredibly useful tool, twin test, for that. For any classification to be considered constitutional, it has to pass both part of this test. In state of West Bengal versus Anwar Ali Sarkar, Supreme Court said, first, there has to be an intelligible differentia, basically a clear, understandable difference that separates the group. Second, there must be rational nexus, a direct logical link between that difference and whatever the law is trying to achieve. It is called doctrine of reasonable classification. Remember it for your prelims. Now, as with many of our fundamental rights, rights to equality is not absolute but qualified. Let's understand terms and conditions of this right. The Constitution gives very specific exceptions because it recognizes that for a state to function properly, some immunities are extremely necessary. For example, president and state governors are immune from legal action for their formal acts, official acts. Same goes for MPs and MLA for things they say or vote inside the legislature. These are not about creating a special class of people, but they are functional necessities to make sure the government can actually govern. Okay, theory is one thing, but the real magic of Article 14 happens when it is put to the test in courtroom. So let's look at a couple of landmark cases which are important for exam purpose too. First, historic Navtej Singh Johar case, which dealt with section 377 of Indian Penal Code. So what did the court find in it? It found that section 377 completely failed the test of reasonable classification. It created a class of citizens based on their sexual orientation, which the court said was not an intelligible differential for a criminal law. There was a simply no rational nexus, no logical link there. In short, it treated equals as unequal. And there was a clear violation of Article 14, therefore. Now let's look at the highly debated Sabrimala entry case too. Here again, Supreme Court applied the rigorous test of Article 14, the twin test. It held excluding women just because of their biological factor, like menstruation, was a form of gender discrimination. The court found no intelligible differentia or rational nexus that connected this exclusion to the core tenets of Hindu way of worship. And all of that brings us back to where we started, to that big opening question. Does true equality sometimes requires unequal treatment? Well, after all this deep dive discussion, the answer you would probably be thinking, and it is yes. Real substantive equality isn't just about applying the same rules to everywhere no matter what. It's about providing equal protection by recognizing that the people start from different places, and sometimes you have to treat people differently to create a level playing field, and that is profound genius of Article 14. And that is why you will find seats in metro are reserved for elderly people, women, children, and disabled people too. So let me know in the comment where else do you find that practical reflection of Article 14. Thank you so much.